Good evening, ladies and gentlemen. Compliments of the season. Happy Easter to everyone. But on this platform, learning never stops. My name remains Oluyemi Adeosun. Tonight on HR Mentorship Learning Series, we'll be looking at a very interesting topic, framework for resolution of employee disputes. Framework for resolution of employee disputes. Tonight, for the opt-ins time, you know when somebody has come so many times and we still love him to come even again and again. We appreciate him, we love him, we respect him, we honor him, Barrister Emmanuel Abrayi. But just for the benefit of somebody who may be a first-timer on this platform, or you are just checking out this YouTube channel for the first time, I would like to introduce Barrister to you. He is really an enigma in the legal and the HR space, the labor space. Emmanuel Abrayi is a senior associate with the disputes within the dispute resolution, labor and employment practice groups at ALEX. ALEX is spelled AELEX. He was called to the Nigerian bar in 2015 and has over 8 years experience in civil litigation, labor, and employment advisory. Emmanuel frequently represents employers and employees in defining labor and employment litigations at the National Industrial Court of Nigeria, Nigerian Court of Appeal, which is the final appellate court in labor and employment adjudication, as well as the African Union Administrative Tribunal. He also handles commercial litigations in Nigerian High Court, Court of Appeal, and the Supreme Court. His labor and employment dispute experience encompass cases on wrongful termination, severance pay, exit benefits, bullying, harassment, victimization, redundancies, labor union rights, labor union elections, occupational injuries, among others. He has also succeeded in instituting, prosecuting, or defending claims on behalf of corporates and individuals. In addition to this, he has handled commercial disputes, instituting, prosecuting, or defending claims on behalf of multinationals, nationals, and indigenous organizations. Emmanuel has also advised on a broad range of labor and employment issues. Emmanuel is a co-contributing editor to the Nigerian chapter of the Employment Law Review, a UK-based publication in 2022. He's also contributed to a number of periodic updates on a varied spectrum of labor and employment law, which is not limited to diversity and inclusion in the workplace gender rights, general employee rights for square pattern bugs, an online publication on labor and employment, and a number of other employment-related publications. Regularly, Emmanuel speaks at events, platforms, forums, and radio shows. For example, he has spoken at the Chartered Institute of Personnel Management, the office on Lagos Talks 91.3 FM, and is a regular, a very, very prolific regular on the HR Mentorship Learning Series for HR professionals and enthusiasts. Emmanuel is ranked as a national leader in labor and employment by Who is Who, legal independent research with clients and peers. He is a member of the Nigerian Bar Association and the International Bar Association. Tonight, speaking on framework for resolution for employment disputes, I present yet again Emmanuel Abrayi. You have the floor.
Thank you very much, Mr. Adeosun. I'm very happy to be here again today. Like you said, it's the opt-ins time, and I always enjoy coming here, having these discussions with HR enthusiasts as well. Thank you for the opportunity as always. Today I'll be speaking about framework for resolution of employment disputes. And I have designed an outline that will guide us through the discussion today. I'll be discussing some of the terms. I'll be looking at common areas of disputes between employers and employees. I'll be looking at types of dispute resolution mechanisms, I'll be looking at framework for dispute resolution processes, and then we'll conclude. Now defining, for those of you who are just joining, Mr. Adeosun had said that, he probably thinks that there are some people who are negotiating with Judas, and we might need to have some form of dispute resolution because there might be an issue arising out of that with the disciples getting angry that there are some persons who are working against the corporate goals of the organization. Let's just put it that way. And that's really how disputes arise in the workplace. It's really about disagreements that occur between parties who have, before the time of the disagreement, enjoyed, some form of cordial relationship or a mutually beneficial relationship amongst themselves, right? Employment disputes, on the other hand, are disagreements that occur in the workplace. These disputes may be contractual or they may be relational. Sometimes the dispute might, come out from the contract of employment itself. Sometimes you have a situation where the contract of employment is not very clear on certain things. Sometimes the contract of employment, there's some form of ambiguity arising from the way the clauses have been drafted. And so you have a situation where an employee is not clear as to what his rights are, what his benefits are. So those are contractual disputes. And then sometimes the disputes may be relational, arising out of relationship between the employees. Of course, as between employees, the disputes may be vertical when it's between superiors and subordinates, or the disputes may be horizontal when it is between same level employees. Speaking about dispute resolution, that really refers to the process involved in settling these disagreements that we had earlier spotted between the disputing parties in the workplace. Now, the framework now for resolving those disputes refers to the basic underlying structure which HR has designed, or which the employers themselves have designed for the resolution of employment disputes. Now, when employment disputes arise, there are common areas where these disputes may arise from, right? Between employers and employees, or between employees amongst themselves, right? Now, non-payment or underpayment of salaries and other employment benefits is a very common area from which disputes arise in the workplace. Sometimes we have situations where the employer, maybe for economic reasons, decides they want to maintain their staff, right? Then an inability to pay salaries come, or sometimes it's really just mismanagement. But whatever it is, sometimes there are those situations where, employers are unable to pay salaries. That's a dispute point. Sometimes it's non-remittance of taxes and social security contributions. So sometimes employees have entered into contracts, and then, they've been told that their net pay is going to be a particular amount. And the reason why they are not receiving the gross is because there are certain deductions that have been made for taxes, for social security contributions, like pension, like National Housing Fund, and the rest of that, and then these deductions are made from the employee's salaries, and the employee cannot see a corresponding credit to their favor with the relevant organizations or with the relevant stakeholders, right? This is a dispute point between employers and employees. You have underpayment of exit benefits. Sometimes employers promise big things, and then when it comes to fulfilling those promises at the end of a tenured employment, or at the end of an untenured employment where the person has resigned, employers then begin to find it difficult to fulfill the obligations that they had earlier said they were going to fulfill with relation to the employment. So that's a point from which disputes would then arise. Sometimes there's contractual breaches of the terms of the employment. Employer has said, okay, when you're going on leave, you're entitled to XYZ amount of money as your leave pay. And then when this employee proceeds on leave and returns and then makes a requisition for this leave pay that he has been promised, sometimes we then find situations where the employer will say, oh, well, we didn't really mean it that way, or, oh, we have canceled that policy is no longer applicable, and all of that. These are, situations where disputes arise between employers and employees. right? Breaches of international best practices and international labor standards. I believe you can go search out some previous recordings of the HR mentorship program, and you would find some places where we have dealt in-depthly with international best practices and international labor standards and what they mean. International labor standards are really just those labor standards that have been agreed by the Committee of Nations as being the proper standards to be upheld by employers in the workplace. International best practices, on the other hand, are practices that have become so prevalent that they have been agreed to be the practices, that should be upheld by employers. And in both situations, you would find international best practices and international labor standards contained in international labor conventions, particularly the conventions of the International Labor Organization and other employment-related conventions that are in operation. Another, instance where you would have, disputes in employment and relations is misclassifications, reclassifications, and disguised employments. It's happening now that employers do not really want to give employees their right of place. Let me put it that way. You have situations where employers want to give employees a different name to make them feel that they are not employees, so that they can deprive them of certain benefits that they should ordinarily be entitled to. So for instance, you would have an employer who claims that a certain person is not an employee, but is an independent contractor. Oh, this person is not an employee, he's just a consultant. Oh, this person is not an employee, he's just an interim manager. Oh, this person is not an employee, we just have him coming on his own time, and then we pay him per, service that he provides, to us. Now, this is really most times a misclassification of, the roles of an employee. And then you have situations where in trying to disguise this employment, contractual documents will then be issued to these persons to state that your position is not an employment position, or you're not an employee for us, you're just an independent contractor, and we'll pay you XYZ amount of money. Now, when they do this, that person who is misclassified as an independent contractor or an interim manager or whatever is named that, these employers come up with part-time, is not entitled to certain things. For instance, this person is stripped of benefits such as pensions, housing contributions, benefits that other persons who are properly classified as employees would ordinarily get. So these are, one of those points of disputes between employers and employees. Sometimes it's not really misclassification, sometimes it's reclassification. A person who has been an employee for a number of years, and then the company just decides, oh, we want to terminate your employment and we want you to reapply to us to be a consultant, to be an independent contractor, to be something else other than an employee, right? This is a point where disputes arise in employment. There are other points of disputes between employees and employers, between employees amongst themselves, which would lead to liability for the employer. So for instance, you have situations of sexual harassment, harassment, victimizations, retaliations, which sometimes arise as between employees, but then you have, the employers bearing liability for those issues, sometimes because of the ratification of those conducts, right? So these are the areas where disputes arise in employment relationships. Now moving on to the types of dispute resolution mechanisms. We usually would divide this into two, and this is where HR executives and HR practitioners should then be careful to apply some of these things, because sometimes some of the disputes that we see going to court do not really need to get there. Sometimes these disputes could easily have been resolved if, there had been some form of, dispute resolution mechanism in play before, parties had to go to court, right? Now, in looking at the types of dispute resolution mechanisms, we divide them largely into two. We have the alternative dispute resolution processes, which is largely known as ADR, and then we have the dispute resolution processes, right? Now, as part of the alternative dispute resolution processes, we have negotiation, we have mediation, we have conciliation, we have arbitration, and then there are some hybrid processes. Those hybrid processes, as we'll see later, are processes that, combine two or more ADR mechanisms to come up with a process that might be best suited for that particular dispute. Now, the first alternative dispute resolution process is negotiation. Negotiation. This is where parties just talk. And this is the first line of defense to any civil claim from a company. And it is always at this point that HR is most suited to take action. The reason I say this is because sometimes situations might escalate. Sometimes it even gets beyond HR, and HR is found to be in a position where they are unable to, take, decisions for the benefit of the company. So negotiation is that first procedure, for dispute resolution. Now, what is negotiation? Negotiation is mutual discussions amongst disputing parties with no involvement of third parties. And this process is aimed at resolving the dispute. It is mutual discussion between parties. It doesn't involve any third party. There's no other person who is involved in the process. It is just the employer and the employee taking steps to ensure that the dispute is resolved, right? Now, mutual discussions among disputing parties with no involvement of third parties, and it is aimed at resolving the dispute. The process allows the parties to consider their worst alternative to a negotiated agreement and their best alternative to a negotiated agreement. Put this very simply, it's just a procedure through which you as HR can actually check the headspace of the employee who is trying to raise a dispute, or to try to, to escalate a dispute. Let me put it that way, right? You get to speak to this person to know, because sometimes it's really just that there is a miscommunication somewhere. There is a misalignment somewhere, or there is a situation where people are just unwilling to accept that, something has gone wrong, right? And or people are refusing to accept what their faults are in that particular situation, right? Now, negotiation helps parties come together to discuss what the issue is and to discuss the best mechanisms for resolving the dispute, or the best way to resolve the dispute. It is at the negotiation stage you would find out that, oh, if I do not resolve this dispute, these are the challenges that I would face, going forward. Then you have mediation. Mediation, unlike negotiation, involves a third party. In mediation, you as HR can, invite a third party person to the dispute. It doesn't even have to be someone outside the company. It could be a colleague of the employee who is trying to escalate the dispute. It could be any person. It could be a senior staff, trying to work as, a neutral third party who has no interest in the dispute, right? It could even be in unionized settings. It could be the head of the union. It could be some of the ESCO members of the union who are coming together to see how they can, de-escalate the dispute or the conflict, right? So mediation is a third-party moderated discussion among the disputing parties in a bid to resolve that dispute or that conflict. Now, the thing about mediation is that it's not necessarily binding. until it is reduced into a settlement agreement or it is filed to be entered as consent judgment in a court of law, right? If it is used as an exit process, maybe this dispute is arising as a result of post-employment issues, it can be used as an exit process, and then the parties can then sign a mutual separation agreement or a mutual settlement agreement, however it is called, between the parties. And the point of the mutual separation agreement is to make the disputing party relinquish all further claims against the company. And this is really very important. And the way it works is that after the mediation process is concluded and parties have signed a mutual separation agreement, we then have a situation where a mutual separation agreement is prepared. This mutual separation agreement works to, let me use the word, kill any further claims that may be made against the employer, or that may be made against any employee, or that may be made against the company. So this is a way of killing the dispute before it is further escalated to court. And it is very important. Sometimes what might be a raging fire might just be quenched even before the public gets to hear about it. Because of course, by the time you go to litigation, right, you will then have the challenge of the fact that that issue is now in the public domain. Everybody has access. Everybody knows what particular thing happened, right? And I'll share an example to you now. On January 11th, I think, or January 20th, a decision of the National Industrial Court was handed down. And I can mention the name of the company because, it's public record and it's also accessible by everyone on this platform via the NICN's judgment portal, right? Total Energies had an issue of misclassification of their employees. They had certain security guards who had worked with them for, some of them 15 years, some of them 20 years. And then at some point, the employees were notified that they were really not employees of Total Energies. And it was really shocking for them to hear that after all of these years, Total Energies did not consider them to be employees. Now, what this meant is that they didn't have, social security, things like pension, things like, housing fund, or even severance benefits that other, quote unquote, full staff are entitled to. They didn't have any of those, right? And many of them were, at that point where they had to retire, and they found to the shock, to their utmost shock, that they weren't even considered as employees in the first place, and then they sued. They sued both Total Energies and all the labor brokers that were involved in their employment with Total Energies. Now, let me further break this down. We have situations now which is a little bit slightly complicated than your usual full staff and contract staff conversations that you'd usually have in certain places like banks and the rest of them, where you have contract staff who are not necessarily considered as employees of the company, but are employees of a third-party labor services provider, right, who provides these employees to the banks or whichever other endeavor. And then you have a situation where these employees have no rights, absolutely no rights, except the rights that they have with this third-party employer to whom they are not even providing any services, right? So here's the thing. Total Energies had themselves in that, similar kind of situation. Now in court, their lawyer argued that, well, these are security guards. They are not necessarily entitled to the provisions that the Labor Act provides because they are not workers within the contemplation of the Labor Act. That if they are describing themselves as security guards, then it means that they are professionals who are not bound by the provisions of the Labor Act. And the court had to distinguish that argument, and even struck down the argument to say that, no, these are lower cadre employees who, regardless of their description as security guards, are actually carrying out manual labor and clerical work But of course, that was the manual labor aspect of the discussion. Point is this: the courts granted exemplary damages against Total Energies to the tune of 50 million naira in favor of those employees. And this decision was granted just in 2024, January. That's this year, January. The point of this is that if there had been, negotiation or mediation or other processes that would have hedged against, this situation that Total Energies found themselves in, it would have de-escalated the conflict, and maybe they could have found ways to compensate these persons who had worked for them for several years with very minimal benefits. The next process in the ADR spectrum is conciliation. Now, conciliation is a voluntary process in which a professional facilitator would assist employers and employees to resolve the disputes when their own unassisted efforts have not succeeded. So mediation and conciliation will usually come in when negotiations have failed. You can actually start mediation without even negotiation, but conciliation works when you have at least tried to resolve your dispute and it fails, and then you bring in a facilitator. That facilitator's work is to search for a means for the parties to reach an agreement. Now, conciliation and mediation might seem a little bit intertwined, but they are distinct in that a mediator would only facilitate the discussion. The mediator doesn't really say much. He would only say, okay, let me hear from you. Okay, let me hear from you. What's the issue? He will try to see what the issues are. He might then have a breakout session with each of the parties. Oh, let me hear from you separately. Let me hear from you separately. And then he'll be able to pick what the issue is and then bring, after this, distinct caucus meetings, will then try to bring the parties together to see how they can, resolve. He doesn't really hand down any decision, or she doesn't hand down any decision for the parties. But the conciliator is different in that the conciliator will try to find the solution and would inform the parties of the solution that has been reached. The next is arbitration. It's also an ADR process. And we would try to be very careful here in looking at arbitration, in the sense that it's a little bit, unique, especially regarding the discussions around it in Nigeria. And I will explain all of that. But to define it, it is a procedure in which a dispute is submitted to one or more arbitrators by the agreement of parties. So usually for arbitration to work, of course, parties can subsequently have a dispute settlement agreement or an arbitration agreement, which is different from the contract or the pre-existing contract. But in most cases, the arbitration clause is already contained in the agreement, the contract of employment. Now, for instance, the arbitration clause is already there, and then, it binds parties to arbitrate the disputes and to choose arbitrators who would make binding decisions on them. This is unlike mediation, where the decision is hardly binding. In mediation, the decision can only be binding if, parties pursuant to the mediation file a settlement agreement, or they enter the terms of the, mediation as consent judgment. The same thing applies in conciliation. The conciliation has to, be enforced via a judgment before it can be binding on the parties. But this is different in arbitration. In arbitration, because there is an arbiter, there is a quote and unquote a judge, but a private judge in this instance, the decision that that person reaches, or the decision that that panel reaches, is binding on each of the parties. Now, as I said earlier on, the arbitrability of employment disputes in Nigeria is sort of a thorny issue because of the uniqueness of, the Nigerian jurisprudential landscape. And I'll explain why. There is only one law that deals with arbitration in Nigeria. And that is, it used to be the Arbitration and Conciliation Act, but it is now amended and it's now the Arbitration and Mediation Act. Now, that act is for the resolution of commercial disputes only. Now, employment disputes are not deemed to be commercial disputes. Employment disputes, and these have been the arguments that have gone on in different cases before the National Industrial Court, where the National Industrial Court found itself unable to enforce the provisions of the Arbitration and Conciliation Act then. And to a large extent, it still finds itself unable to enforce the provisions of the Arbitration and Mediation Act now, because in this act, the National Industrial Court is not recognized as a court before whom an arbitral award can be taken for enforcement, or even as a court before whom parties can go to get what they call interim remedies, or interim measures, right? But still, there are some aspects of arbitration, employment disputes that might seem, unarbitrable, things like unfair labor practices, and I would use that advisedly, torts and the rest of that. So it then becomes a public policy issue, and people begin to, raise objections whenever parties have brought an employment dispute for arbitration. Still, there is a very recent decision of the National Industrial Court where the National Industrial Court enforced an arbitral award. Maybe I should explain what an arbitral award is. An arbitral award is like the judgment of the arbitration panel or the arbitrator after the conclusion of the arbitration proceedings, right? They come up with what is called an award. Now, that award, even though it is binding on the parties, right? If there is an issue of non-compliance with the award, parties would usually take the award to court to try to enforce it in court, right? So we then have, we used to have issues with enforcement. Now, in the recommendations section, as we go further, I will try to then advise on, steps that HR can take in devising their internal policies to allow for arbitration. And one very important thing is that, you should not make the arbitration pursuant to the Arbitration and Mediation Act. Yes, there's the argument that parties can actually just agree to, make any law, the governing law of, the dispute that they have, right? But, the law we have in Nigeria, which is the Arbitration and Mediation Act, it used to be the Arbitration and Conciliation Act, right? That law is limited to the Federal High Court and to the State High Courts. But if you decide that you're going to arbitrate a dispute, you don't necessarily have to say, oh, it is pursuant to the Arbitration and Mediation Act. It is fine to just say you will arbitrate the dispute. The disputes would be, the arbitrators would be decided by the parties. The downside to arbitration as a means of settlement of employment disputes is really that it is expensive, and sometimes the value of the employee's claim. And I have found situations where employers like to, try to enforce arbitration because to some extent it is sort of what's the word, favorable to them financially. It is easy for the employer to say, okay, let's go to arbitration, because they know that it will be impossible for the employee to, pay for arbitration. So, there's that. And those are the challenges that might be faced with arbitration as a means of, resolving employment disputes. Aside arbitration, you have hybrid processes. Hybrid processes, is, mixing negotiation with mediation, negotiation with conciliation, mediation with arbitration, so that you then have a mediation arbitration, or you have a conciliation arbitration. All of these are just hybrid processes that arise from the combination of any of the two alternate disputes or alternative dispute resolution processes. Now, moving on to dispute resolution processes, you would recall that I had said that there are two types, broad types, categories, if you put it that way. There is the alternative dispute resolution processes, and there's the dispute resolution processes. The alternative dispute resolution processes are all of those processes that I have now covered, but the dispute resolution processes is basically litigation, right? It's litigation. Now, this is the process of prosecuting or defending a suit in a court of law. I would always say that HR should try to de-escalate employment disputes so that it doesn't get to this point, because when it gets to this point, it's out of your hands. It's totally out of your hands. And that relationship would be forever scarred. A couple of weeks ago, I was in court for a matter where we're defending a particular multinational, and one of the employees had been terminated, but he had pleaded to be allowed to resign, and the company had allowed him resign, but then he then brought this case against them, claiming almost over 100 million, and of course, the company is definitely going to defend that kind of claim, and then I noticed that the person who was the witness for the company and this former employee had a very hot argument after the proceedings of the day. The former employee who was the one who brought the claim, was using many uncouth words. You are a nobody. You are just a low-level staff. I wonder what you're feeling like coming to testify against me, blah, blah, blah. And I wondered to myself, how would the relationship of these two people be for the rest of their lives? It is hard to see how that relationship would ever come back to what it used to be. That's what litigation can do, right? It's the reason why you must ensure you don't get there. Don't get there. Try to resolve the dispute with everything you can, right, before it escalates. Now, employers are better off, as I have said, resolving disputes than going to litigation. But there are some times when you just have to go to litigation, because if you don't litigate that issue, you would create a negative culture within your organization. So say, for instance, someone steals, right? If you resolve it with him and then you give a pat on the back and then you enter a mutual separation agreement with him, you don't want trouble, you just want to be easygoing, you will create a culture, because people will then feel that they have an expectation to be treated the same way this other offending employee has been treated. So there is the way to maintain that fine balance, knowing when to escalate the dispute and when not to escalate the dispute. But of course, it's up to HR and also up to the legal team to decide which disputes they intend to escalate and which disputes will be de-escalated. But of course, there are some times that some employees, they really believe this thing that they said is the motto for 2024, no grief for anybody. And even when they are wrong, they will insist that they want to go to court. There's nothing you really can do. You just have to defend the action in court, and of course also counterclaim if you have grounds for counterclaiming. Now let's look at the framework, and I have just written 4 things, and if you can take these 4 things home today, you would have been able to grasp what the framework for resolution of employment dispute really is. Because sometimes the challenge is that the structure for dispute resolution is not there. Many contracts of employment do not contain dispute resolution clauses. So the employee is on a free ride to just escalate a dispute when ordinarily there should be a dispute resolution clause in the contract. If there is no dispute resolution clause in the contract, the employee handbook also forms part and or is part and parcel of the employment contract. So that employee handbook should have a dispute resolution section that deals with disputes. Now, the first framework is to, as much as possible, avoid the disputes. Uphold strict compliance with your internal processes. And one thing I have found to be a major issue is that C-suite executives don't even know what the handbook says. So HR, as much as possible, must hold sensitization programs for your executives for them to see what is in the handbook. For instance, now, let me give you an example. Termination of employment must be for a reason, not just a reason, must be for a valid reason, which must be contained in the termination document. But sometimes HR is acting on the, you are fired, get out of my office, that the C-suite executive has said. And the termination document does not contain a reason for the termination. That is already a dispute that can cost the company when the court decides the issue and damages are ordered against the company. Now, international best practices are so prevalent now in the labor and employment space that for any employer to make the mistake of just breaching international best practices willy-nilly would really cost that employer. And it is very important that employers comply, and HR must then help employers comply. Making the workplace, for instance, toxic so much that, you just have people quitting on constructive dismissal grounds because they have had a senior employee or an executive employee treat them in such a way that they couldn't reasonably have been expected to continue in that employment. It's already a ground of dispute, and it will be very unfortunate in 2024 for you to be in that organization where, international best practices are just being breached willy-nilly. Now, but there's a way to create a structure that sort of is a framework for your dispute resolution processes, right? Now, you must ensure that your internal processes, that's your handbook, your policy documents, give the employers control of the dispute process before it is escalated. So, and also to create, policies that, that makes that dispute resolution process a condition precedent to litigation. And I will explain. A contract is a contract, and you cannot complain about the contract after the contract has been executed, right? So if the contract says that in the event of a dispute, an employee is required to take XYZ action. If that employee chooses not to take that action and runs to litigation, that employee has breached a condition precedent. Now, the court will not exercise its jurisdiction until the condition precedent has been fulfilled. I know I'm using many legal jargon, so I'll find a way to make it simpler. If your process says, and I'll just use this very loosely, before you eat rice, drink a cup of water. You are not allowed to eat rice until you have had a cup of water. That drinking of the cup of water is a condition precedent to the eating of the rice. Now, it's the same thing. If in your policies, you have a dispute resolution policy that creates procedures for escalation of grievances, creates procedures for, resolution of disputes. This goes beyond just disciplinary procedures, right? Procedures for resolution of disputes specifically designed for the resolution of disputes. If you have, that as part of your handbook, or even if it's not currently part of your handbook, you can design a dispute resolution process which you can then spread around the office for people to, give their consent to. In that dispute resolution process, you can then place in a negotiation clause which would bind the employee to discussing with HR, right, the reasons for the dispute. This would only come where, of course, there'll always be misunderstanding in the office, there'll always be disagreement that can be resolved outside that dispute resolution process. But when an employee is seeking to escalate a dispute outside the company, then this dispute resolution process will then kick in to bind the employee to a negotiation, to a mediation, to a conciliation, to arbitration, right? Not arbitration pursuant to the Arbitration and Mediation Act, but just, arbitration, doesn't need to be made, because once you make it pursuant to the act, then, there'll be all these arguments and you would almost not be able to even rely on it, when the time comes. But then you have that process that says you have to take these steps before you go to litigation. If that employee then jumps the gun, you will then file what we call an application in court, right, for stay of proceedings, pending the employee's compliance with your own internal dispute resolution mechanisms. Very important. Now, this is the framework you must create. There must be a dispute resolution, internal dispute resolution mechanism in your organization to make it easy for you to resolve your disputes before they go to court. Now, in conclusion, you would find, if you have followed previous sessions that I have taken, that my conclusions are almost the same, because this is really the solution for, labor-related issues, labor-related disputes, and the likes, right? Now, HR should, in conjunction with their legal teams, design dispute resolution clauses that allow for negotiation and mediation as a first step to litigation or arbitration, right? There should be that condition precedent created in your documents. And employers should strongly consider having a legal officer that is trained in labor and employment law as part of its HR team, right? The decisions of the National Industrial Court should be followed keenly. I always say this: the National Industrial Court is the only court in Nigeria that has its judgments online via its judgment portal. It's the only court. A decision can be handed down today, and by evening of that same day, that decision is online, available for you to read. So there's really no excuse, right? There is really no excuse, really. So you must then keep yourself abreast of the decisions coming from the National Industrial Court. I usually would do quarterly reviews of the decisions of the National Industrial Court, yearly reviews of the decision of the National Industrial Court. When those documents are ready, I would share in any of the, I think I belong to one of the HR mentorship groups. I'll share there, I'll share with the head of the HR mentorship group so that it can be circulated. Now, well, this goes without saying, but I mean, the employers should also seek legal counsel whenever they find themselves in dispute situations. I find that in many situations, employers are not seeking legal counsel. They are taking actions that are contrary to labor standards, and they are bringing, very, very heavy damages on both their company reputation and also on their books, right? So it's good for you to seek legal counsel before you take some of these actions. That would bring me to the end of tonight's session. Thank you very much, everyone. Over to you, Mr. Adeosun.
Thank you so much. That has been a very excellent submission. I'm glad this session held tonight. Quickly, we would like to take maybe 2 or 3 questions and contributions or comments. I can see Olamide Hassan. Please, you can unmute and direct your question to the barrister. Olamide Hassan, if you have questions, please raise your hand so that we recognize you. Thank you, Olamide, my brother. Over to you, sir.
Mr. Adeosun, good evening to you, sir. And my barrister, thank you for this wonderful session. I really appreciate it. I've gained a lot. I have a question, and I have 2 questions, but let me take it one after the other. So the first question is that one of my friends, he reached out to me yesterday that this contract has been terminated. According to the mail the HR sent, it's just that your contract has been terminated effectively today. So, and salary was made 2 days ago. That was 2 days ago, and the contract was terminated yesterday. So I was asking, do I know that? I'm being curious now, because is it that this employer is not liable to pay this one more because notice was not given? So what I'm convinced if the employer is liable to pay for 1 month in lieu because the contract was terminated after salary has been paid. That's the first question. Now I think I have an idea that the person told me that the contract that that he signed with the employer says that the employer or the employer can terminate the contract for not for cause. So what I'm looking at now is not that this clause is against the international labor standard. Why would you terminate? Why would the employee or the employer terminate without for cause? Because that without for cause, I think, is that you can terminate without reasons, in which I think you mentioned in your session that it is against international labor standard, that employer should give reasons for terminating contract the employee. So that's my 2 questions. Thank you very much, sir.
Thank you very much, sir. Well, let me just quickly answer your question. To start with, if the contract says you cannot terminate without paying salary in lieu of notice, then you cannot terminate without paying salary in lieu of notice. That's just it. So even if the contract was terminated after the salary has been paid, that does not satisfy the payment in lieu of notice for that should have been given to that employee, because the notice period is a 1-month notice period. So if you have not given the employee that 1-month notice period, you're liable to pay that employee 1 month's salary in lieu of that notice that you ought to have given. The point is really that it's a sort of security measure for the employee, that if you don't notify me of this termination, then you should pay me salary in lieu of notice. In some organizations, it's not even 1 month. In some organizations, it's 3 months. In some organizations, it's 6 months. I handled an issue recently, and the employer had to pay 6 months salary in lieu of notice for terminating that employee without notice, right? So there's that. Then, the termination must be for cause. Article 4 of the ILO Termination of Employment Convention of 1982, that's the Convention 158, requires that if there is going to be any termination of employment, there should be a valid reason for it. And that reason must be connected to the performance or conduct of the employee in question. 2 things, the performance or the conduct of the employee in question. So you cannot just terminate an employee's employment just for the fun of it without giving that employee the reason for the termination of the employment. Beyond giving reason for the termination of the employment, there is also the issue of, giving the employee an opportunity to improve their performance, or giving the employee an opportunity to defend themselves if it's a disciplinary issue. So those are international labor standards that the National Industrial Court is enforcing even till today, right? And I'll give you an example. There is the Total Energies decision of the Court of Appeal that was granted in 2023. And then in that decision, the National Industrial Court said, oh, well, if an employee does not have a contract of employment tying them to a particular employer, then they cannot say the employer is their employer or that company is their employer. The National Industrial Court has distinguished that decision in a January 2024 decision where it said, no, there is a Supreme Court decision of Shena Securities that lists what we can look at to say who an employer is and the relationship between employer and employee, right? So it cannot just be the fact that there is no contract of employment. The Labour Act also says that the contract of employment can be implied from even the conduct of the parties, right? So my point to you is this. There is an international labor standard that the company is expected to comply with, and their failure to comply with that international labor standard is something that can cost them in damages. Many times, a lot of people leave it for God, and it's a problem. And I understand that employment claims can be costly. I understand that because there's hardly going to be a lawyer who will take up an employment claim for you for free, right? There used to be a time when lawyers don't ask for money. If you look at that our gown, it used to have a pocket at the back where people would just drop money into the, to that pocket for the lawyer to take care of himself, right? But things have changed. It's no longer like that, right? So the lawyer too has to pay house rent, has to eat and all of those things. So it's hard for him to just take on that work without pay. But as much as possible, even if you yourself, you can actually represent yourself. You have a constitutional right to represent yourself, right? And that person can start by writing a letter to the company. This is my contract. This is what you're bound to do. This is what international labor standards require of you. This is how you have failed. If I go to court, this is what I know I'm entitled to. If you fail to accede to my demands, this is what you're likely to lose. Just write it in a very sound way and issue that letter to them and wait for their response. And if they don't respond to you, you can then start looking for ways to. And the good thing is that the National Industrial Court has the rules of court on the website, right? You can actually get the rules of court, study it, look at the forms with which you can comment an action and commence the action. Really, nothing stops you from doing it, right? There might be some technicalities that only lawyers understand, right? But still, you can actually still represent yourself, right? And then, in many of those cases, you might even find lawyers who can take on the matters for you pro bono, and you don't have to pay any money for it, right? So that's really just it. That person has been wronged and has a remedy in law. I just hope that answers your question.
Thank you so much. That's the only voice question we'll take tonight. However, we'll quickly, Barrister, attend to all the questions in the chat box. We have one here. One I've already responded. Someone was asking if the National Industrial Court's judgments are accessible, especially to non-lawyers, and the answer is yes. I've also dropped the judgment portal of the National Industrial Court link. I've dropped it on the chat box. You can just pick it up from there. Then Ijoma says here that, thank you, Barrister. If the employee is no longer a staff of the company before litigation, is the company's conflict resolution still binding on the ex-employee? So I'm suspecting that this person has resigned, that is an ex-employee still subject to the company's conflict resolution.
Thank you very much. So let me just answer the question like this. Employee rights in your are 3 levels: the pre-employment level, the employment level, and then the post-employment level. The contract of your contract of employment also has certain implied terms which might not be clearly written in it. Now, the dispute resolution, let me also say that there are certain terms of employment contract that survive the termination of the employment. So whether the employment has been terminated by resignation or has been terminated by, a sack or a termination of the contract of employment, there are certain clauses that by their nature must survive the employment or the termination of the employment. A dispute resolution clause is one of those kinds of clauses that survive termination. So whether or not the employee has left, has resigned, has been terminated, that is what the dispute resolution clause is there for. So the employee would still have the benefit of relying on the dispute resolution clause to push their claims for resolution of the dispute, whether they want to escalate it. But if there are clauses in the contract that requires you to take certain steps with the company, like mediation, you have to make recourse to that. But then it is not a clog on the wheel of justice, because we have found that from time to time, employers try to run away from their obligations to abide by these clauses. So they ignore the employee, and if the employee is trying to take certain steps to fulfill the terms of that dispute resolution clause, they write back to the employee and say, oh, you don't have any right to do this. That is called unreadiness to settle or unreadiness to arbitrate if it's an arbitration clause, right? So if you then institute an action and they come to say, oh, you are bound by this dispute resolution clause to take certain actions before you can escalate your dispute, you then come out and say, yes, I wrote you, this is the evidence of what I wrote to you. You refuse to comply with that clause, and it is for that reason that I have taken this next action, and the court is going to uphold it. There's a decision of the National Industrial Court, Sheikh Wadraogo versus Uber Systems Nigeria Limited, where the employee was bound to an arbitration clause, and when his employment was terminated, he wrote a notification of arbitration to Uber and said, this is my notification of arbitration, let's commence arbitration. And Uber wrote him back and said, you have no further rights under the contract, we have no obligation to take any further steps with you. And then by the time he now filed an action at the National Industrial Court, they filed an objection to that action, saying the court should stay proceedings for them to go to arbitration. And we argued that no, they're not ready to even go to arbitration. This is what they wrote to this employee to say they're not ready to arbitrate, and that the employee has lost all his rights relating to the contract. And the court agreed with us and said, yes, you were not ready to arbitrate at the time when you were called upon to arbitrate. So you cannot rely on your own unreadiness to stall the claimant who has decided to bring the action now to court. So the point is just that the fact that the employment has been terminated does not mean that the dispute resolution clause cannot be upheld. It can be upheld, and it's usually upheld. I just hope that answers your question.
Very, very insightful. I particularly like that statement on readiness. On readiness, that sounds very interesting. My sister here, Anna, says, please, how does one handle an employer who refuses to confirm confirm its employee's appointment and ask him to leave the business with a letter as non-confirmation of employment? How can this issue be handled?
Thank you very much. So here's the thing. The National Industrial Court has in several decisions said that if an employer fails to communicate non-confirmation within the period stated for confirmation, it will be deemed that the employer has confirmed that employee, and that employee becomes entitled to all the benefits that a confirmed employee will be or is ordinarily entitled to. So that, employers will not rely. So there is this thing on relying on your own wrongdoing to claim a right. And the courts are always angry when employers try to do that. If you are supposed to confirm this employee within a time frame, you must confirm that employee within that time frame. If you fail to confirm the employee within that time frame, the court will confirm that employee for you by deeming that the employee was confirmed on the very day the employee was supposed to be confirmed. So if an employer then wakes up from sleep 8 months later, 10 months later, 2 years later, to issue a non-confirmation of employment letter, that non-confirmation of employment is more useless. In fact, the paper on which it is written has more use than that non-confirmation of employment. The problem, and I'm almost getting very passionate, the problem is that people refuse to take the steps that they ought to take, sometimes for fear of, sometimes the industry you are working in may be so small that if you take certain steps, your chances of scaling up within that industry might be affected and all of those things. But it's when people keep quiet that these things, continue to to go wrong. So issuing a non-confirmation of employment letter long after the employee ought to have been confirmed goes to no issue. Goes to no issue. So there is nothing really that an employer can do when he ought to have confirmed and then he fails to confirm and then wants to rely on his non-confirmation as a basis for exit. No, it doesn't work that way. The employee has already been confirmed as of the date he was supposed to have been confirmed. So best thing for HR to do is, if for instance you have if the confirmation doesn't lie with you as HR, maybe the executive still has to take that decision and they have not responded to you as of the time that employee is supposed to be confirmed, it's best for you to issue a communication letting that employee know that his employment has not yet been confirmed, and whilst you are waiting for management approval, you would advise him to improve on XYZ areas. So you also as HR ought to have been monitoring his progress to see if, or getting feedback from his HODs and those who are responsible for him to see if he's really, a candidate for confirmation. The truth of the matter is that an employee who is going to be confirmed, HR, you almost always know sometimes 3 months into the employment that, oh, this person is going to be confirmed because of the feedback you're already getting from, the persons he's working with or from his managers, right? But if you keep quiet and 6 months elapse or 3 months elapse and the person you've not issued any confirmation letter, then you now remember in the year of our Lord 2025 that, oh, this person, we didn't confirm him, okay, let's terminate him for non-confirmation. You've lost that right. You slept on it. So you can't terminate him based on non-confirmation. You have to have another reason for that. I just hope that helps.
Thank you so much. We have 2 more questions, but I will combine the 2. So William says here, what is the legal requirement for making a role redundant? And Chidima here is saying, as an employer, she's not the employer or representative of the employer, can I terminate an employee contract based on not being able to pay salary? The company don't broke, they don't cry.
All right. Well, so let me start with the redundancy bit. For you to terminate based on redundancy, 2 things to look at. What does your contract of employment say about redundancy? If your contract of employment is silent on redundancy, then what kind of employee is this person? Is this person a lower cadre employee performing manual labor and clerical tasks at the office? If that is the case, you go to the Labor Act. The Labor Act tells you what you should do. If this person is not, a manual laborer or a clerical worker, then it means that the provisions of the Labor Act do not apply. However, the international best practice on this point is in Articles 13 and 14 of the Termination of Employment Convention. Those 2 provisions require that for redundancy purposes, you should relate back to the national law and practice on redundancy, which means that you are going back again to the Labor Act, right, to look at what the Labor Act says. Now, the Labor Act says that when you want to terminate for redundancy reasons, you should contact the union, right, to discuss the reasons for the redundancy with the union. You should notify them of the reasons for the redundancy. When you have notified them for the reasons of the redundancy, you then have to negotiate the redundancy benefits with the affected employees, right? Now, when you are notifying the union, you also tell them the number of employees and the categories of employees that will be affected by the redundancy. When you have done that, you will then negotiate with, the union and their members on how much we paid as redundancy benefits. Sometimes, if you're lucky, these things are already contained in a collective bargaining agreement, right? But if you have to do these negotiations afresh, you'd have to negotiate with the union. If there is no union, you negotiate directly with the employees. When you have negotiated directly with the employees, you then, after negotiation and you have reached a decision on how much we paid as redundancy benefits, you then apply the principle of last in, first out. Now, that redundancy should not affect your longest serving staff, except if the longest serving staff is really of no use to the company, because the principle of last in, first out is subject to, factors of merit, reliability, and the rest of them. So it's not just sacrosanct that because someone has been there for 5 years or 10 years, he has to stay when the redundancy process is ongoing. No, right? Then you can then terminate. When you terminate, you then, in that termination letter, you will state what the redundancy benefit is, what the exit benefits are. You will state that the reason for the termination is redundancy, right? You put the redundancy benefits, you put all other exit benefits, and you have to pay these benefits contemporaneously with the termination of the employment, meaning as you're terminating, you're paying, right? Of course, if the money is not available, if you can ensure that some part of it is paid contemporaneously, and then, maybe you advise the employee on when next they will be paid. The international labor standard on that is that you must pay within a reasonable time. Reasonable time is usually a subject of conflict, but sometimes 3 months is mostly accepted as a very reasonable time within which to clear, all those monies. Now, for not being able to pay salary, that's also a redundancy issue, because even though in the Labor Act, it defines redundancy as as arising when there's excess of manpower, but under the Termination of Employment Convention, it defines redundancy as arising from reasons of when the structural issues and issues relating to the reorganization of the company. And of course, when you're looking at reorganization or corporate restructuring, sometimes it arises from things like bankruptcies and being broke, if you want to put it loosely, right? So yes, if you find that you are unable to pay salaries, it's a redundancy. So you cannot just throw out that employee. You advise the employee on the fact that there's now a redundancy of his role due to your inability to pay salaries, and you have to find ways to abide by this redundancy procedure that I have also talked about. I just hope that helps.
Barrister Emmanuel Abraye, as always, this has been a very, very interesting engagement, both your presentations and the response to all the questions that have been thrown at you. I'd like to say we celebrate you. We don't take this for granted. And permit me to also celebrate Madam Ruth Abraye. She's always there on every call. Maybe one of these days we'll feature her and you will listen to her. Thank you so much, ladies and gentlemen. I'd like to celebrate and thank everyone who joined this call tonight at this August period. Again, in the next 1 hour or less, this will be on the YouTube channel. Do well to listen, share, and get wisdom. Ladies and gentlemen, again, I would like to say thank God it's Friday for obvious reasons. Happy Easter. Good night